not in C.
Mr. Green, if Justice Barrett is wrong, then what work is C2 doing? I mean, it seems like you've just now re-articulated only the theory of C1, and you're saying that you have to make it into C1 in order to be, to have this statute apply. So can you help me at least understand, under your theory, what additional thing does C2 offer?
Let's look at the verbs of C1, which are alter, destroy, mutilate, and conceal, and let's think about their antonyms. So one, instead of destroy, would be actually to create. So one could use some sophisticated computer program. We've heard an awful lot about AI, and we've heard about the possibility of deep fake photographs. So I think you would violate C2 if you created a photograph that established your alibi in some extremely sophisticated way that would get it admitted into evidence, or make it, or you submit it for evidence would probably be where the crime occurred.
So you're saying there are other things other than particularly altering, destroying, mutilating, or concealing, but it has to be limited to a record?
Not necessarily, because, I mean, one other example, if I might, Your Honor, would be not to conceal, but to disclose. So if I disclosed a witness list in a large multi-defendant drug trial, my purpose in doing that, though I haven't altered the document, would be to intimidate the witnesses or prevent their attendance. That, on our submission, would also violate C2.
All right, can I just ask you one other question, just so that I can fully understand your theory? You keep using the term evidence, and that does not appear in the statute. The statute C1 says record, document, or other object. Now, I appreciate that, evidence can be such a thing, but you can imagine a world in which those two are different. So where does evidence come in your theory, and why is it there?
Well, the title of the statute refers to tampering with witnesses, victims, and informants. But along with witnesses, victims, and informants comes evidence that they provide, whether in the form of testimony or whether in the form of documents.
No, I understand, but the statute, the provision we're talking about here, does not use the term evidence. And so, and instead, or in addition, it uses the term official proceeding, which is elsewhere defined not in terms of, court proceedings or investigations. It's just a proceeding, before Congress. So is it your argument that the only thing that this provision covers is something that is tantamount to evidence in an investigation or trial?
It is, Your Honor, and we're not limiting it. Our position does not limit it to documents or records. I would submit C1, which we say carries into C2 through the otherwise clause, when it says other object, is pretty broad. And it need not be as 1512F provides. It need not be admissible. F. It need not be admissible. So it could cover things like electronic records. It could cover communications. It could cover emails. It could cover all kinds of things that we think get used by fact finders in a formally convened hearing.
I mean, just to take you back to